Tristan Levitt, attorney for Gary Shapley, the former IRS supervisor. Your client, Mr. Shapley, he requested whistleblower protection from Congress in April because after 3 years running the investigation into Hunter Biden's taxes, he wanted to come forward and explain how he thought this probe had been handled improperly. Can you walk me through this initial stage?
Yeah, so the technicalities are actually even a bit more nuanced than that. So when someone makes a protected disclosure in the United States, government employees can disclose various types of information of wrongdoing, and those are automatically protected by the law. What makes Gary's case unique, he's a senior supervisory special agent at the Internal Revenue Service, which is our tax collection agency, and he wanted to be able to disclose information about this investigation in detail. And there are laws that protect the privacy of taxpayers in the United States. So he had whistleblower protection if he needed to be able to, in more detail, make a disclosure. He wanted to make that disclosure to Congress. So the initial letter went in April. We had a period of working with the House Ways and Means Committee and also with the Senate Finance Committee, both Republicans and Democrats on those two committees, to arrange the terms of first us coming in to provide a proffer to identify the types of information that he wanted to come forward with. In order to do that, the committees had to designate both myself and another attorney to receive that confidential taxpayer information. So until we got that from the committees, even we didn't know the full extent of the disclosures Gary wanted to make. But that interview, which was about a 5 to 6 hour of questions, was, his opportunity to share what he wanted to come forward with, which was that in the investigation of Hunter Biden, it was treated differently than any other case he'd seen in his 15 years at the IRS. There were many, many examples of preferential treatment where Hunter was, there were investigative and prosecutorial decisions made that have not been, made in any other case that he's seen. It was always to the benefit of Hunter.
Gary Shapley was seeking whistleblower protection in April, and then after they've taken this vote to release the transcript of the testimony, were House Democrats on the committee willing to do this, or House Democrats in Congress willing to kind of go ahead with this?
Well, they were a part of the questioning, so they had questions for him as well as the Republicans. Both sides questioned him. When it came to taking the vote on releasing the transcript, all of the Democrats voted against releasing it. There was the transcript of Gary and also of a second IRS whistleblower, the case agent on the Hunter Biden case. And so for both of these transcripts, it was a straight party line vote with Republicans voting to release it and Democrats voting against releasing it. But they've had the opportunity to ask him questions. And the Senate Finance Committee Democrats are in the majority. There are more of them on that committee. And so, again, from the very beginning, it was really important to Gary that this be a bipartisan process. It's not lost on him that these allegations impact, potentially a sitting president, and also that they tie into, some information that some Democrats would rather not hear. But he wanted to make sure that he did it by the book and that he talked to both sides evenly so that everyone could see he doesn't have an axe to grind. He just wanted the truth to be known.
What has the IRS and the Department of Justice said about their decision to stand down Gary Shapley and his entire team of agents when he did come forward with these allegations and when he was originally seeking whistleblower protection? Or as they would put it, he was retaliated against, or what he would say, even though they weren't far from making a decision over what to charge Hunter Biden with?
They basically have not addressed it substantively. They have said, DOJ has said that he was not retaliated against. There is some ambiguity about what prosecutorial discretion there is for picking who, for saying we want different agents. It's not something that anyone at the IRS has ever seen before, and it's not really a typical prosecutorial discretion question. But they not only took Gary and his team off, it appears that they also got a fully clean new set of prosecutors as well, which raises some questions. They may argue that because of allegations of misconduct, they felt that it needed to be seen by clean eyes. But it raises the question of what these new prosecutors who had only been on the case for about a month, how they could possibly know all the years worth of evidence and all the information there that you would need in order to, in good faith, engage in plea deal negotiations that accurately reflect the government's evidence against Hunter Biden.
So on that, well, Hunter Biden will plead guilty to 2 misdemeanor tax charges in the plea deal made with the Justice Department. But your client has claimed that this is not the outcome that they were working towards. What other charges were on the cards for Hunter Biden?
So they were looking at multiple different tax years going back to 2014. And for the 2014 and 2015 tax years, that information those tax years would have been filed while Hunter was living in Washington, D.C. And so U.S. Attorney Weiss had to go to the U.S. Attorney for the District of Columbia to try and seek their approval. Those charges included foreign income in 2014, where Hunter had filed a tax return that left off his income from Burisma, the Ukrainian energy company. And so he received guidance from his own advisor saying, you need to file an amended return because what you filed is false information. So that's a felony charge. And so that 2014 and 2015 were significant years. That would have been a significant leverage for the government in any plea deal. Because of the unwillingness of the DC U.S. attorney to charge it, these charges were allowed to expire. They had a statute of limitations, and so they expired in November of 2022, and so are no longer available for the government to charge any longer. But that's what part of what would have been a bigger case. The other one that really stands out is for the 2018 year. So for each of these years, the IRS recommended, again, felony charges for 2014 and for 2018, and then misdemeanor charges for the other years on failure to file and or failure to pay. But for 2018, again, submitting false information on a return, Hunter marked as business expenses a number of charges for things like prostitutes, a membership to a sex club, even a hotel room for what is allegedly his drug dealer. And as Gary outlined in his interview with Congress, Hunter's own accountants came back and said, we can't charge these as business expenses. And Hunter insisted that that's what needed to be done. And so, again, you have a slam dunk felony case there for false information on the returns. And all of that just washes away with this plea deal just for a couple of misdemeanors.
If Gary Shapley and his team of agents had their way, if they got the charges in motion, would Hunter Biden be facing jail time?
I think very likely, yes. I do think it's important to identify that the way the system works, investigators simply gather the evidence. So, I don't know that Gary has a way. I don't know that he has an outcome that he thinks should have happened, other than that in the investigation, they should have been able to look into all of the investigative leads that came up. They were turned down at many avenues. And then once you gather that information, you hand it over to the prosecutors. And, there are prosecutorial decisions that happen at those points, but this was treated differently than other cases that anyone there had seen before. And so that's the key thing. Gary Shapley doesn't have some sort of axe to grind against Hunter Biden, but he believes that Americans should be treated equally here in the United States on their taxes.
Well, on that note, what will it say about the justice system if the judge does sign off on this plea deal?
Well, that's a question above my pay grade to some extent, right? At the end of the day, the judge is going to have to look at the information that the government is providing. The government will need to provide, obviously, the plea deal will have details in there of what Hunter is agreeing to. So some key questions are, is this absolve him of all past charges or even future tax charges? What information is Hunter admitting to? Does he, in the statement of facts, acknowledge the false statements in 2018? Does he touch on the earlier years at all? These charges are just for the 2018 and 2019 years, but are the other years encompassed in the statement of facts? So any judge is going to have to look at those. And there's also been talk in Congress of also potentially weighing in to identify their equities and the equities of the American people, to say that the people, both deserve to have all the facts, and then that, the full scope of the investigation deserves to be reflected in the prosecution. So what a judge does with that is your guess as much as mine.
In an interview with MSNBC the other day, Hunter Biden's lawyer, Chris Clark, said a fair outcome would be for the judge to let his client be able to get on with his life. What do you make of that comment?
At the end of the day, every American wants to be able to get on with their life and not be, hounded by the government. But when you break laws, there are consequences. And, that's why the government was investigating Hunter Biden to begin with. So
Yeah.
he's not ultimately, equal justice under the law is that when you break the law, there are consequences.
Your client has alleged that this investigation is unlike anything he's ever witnessed, as you said before, and that it had examples of preferential treatment, conflicts of interest, and that investigators were basically left out of reviewing important evidence. Who does Gary Shapley believe was at the centre of this decision?
If you read the transcript, you see that it's not a centrally, masterminded conspiracy in some way. Certainly a central figure is Assistant U.S. Attorney Leslie Wolf. She worked in the Delaware U.S. Attorney's office, and she was the primary one shutting down many of the investigative avenues. Her claim to the investigators was, we won't get that approved, or we're not going to be able to get buy-in on that. So, whether she would argue that she was simply parroting what she was hearing from higher ups, Gary doesn't know. He only knows, the interactions that he had. But again, it's clear that decision after decision benefited Hunter Biden. His leadership was never there to back him up when there were hard decisions to be made. They basically washed their hands of it. They made him the point person, which is not something you would typically have an assistant special agent in charge or a supervisor special agent, which are the two roles he had throughout the investigation, making these key decisions. A supervisor special agent normally isn't interfacing directly with the U.S. attorney. Normally it's a higher level official within the agency. But as they say, big cases mean big trouble. And others within the agency at the IRS just refused to engage on them when he raised problems and said, we're being stymied. These prosecutors are blocking the investigation. The IRS basically just left him to drift in the wind and figure it out on his own.
How often was his investigation interfered with? Was he ever allowed to conduct the search warrants that he requested, as seen in his testimony? And did he ever have access to Hunter Biden's laptop?
So it's a complicated answer. For example, on the laptop, he did not ever get direct access to it, nor was he ever given something till this is the full image. He got information that he understands came from it, but there was never anything definitive saying, yes, this is all of the evidence, this is everything that's out there. Similarly, with the investigation, there were search warrants that were not ever able to be executed, but there was some, there was part of the idea, right? If Hunter's attorneys are asked for material and they provide some material, then he'll never know if that's all of the material, if there's more there. There was a storage unit in Northern Virginia, which is just south of Washington, D.C. And when agents went to interview Hunter Biden himself and a number of his other associates on December 8th, I believe, of 2020, which was a significant thing because it had been put off again and again and again until the 2020 election and thereafter. So they're finally able to go overt with their investigation. And when that happened, they learned that there was this storage unit in Northern Virginia that had a lot of the business papers that Hunter had moved when he closed down shop in Washington, D.C. Investigators wanted to issue a search warrant to go and look in that and were stopped from doing so. But again, to this day, they don't know if ultimately, basically, they were relying on the voluntary production of documents from Hunter and his attorneys to have any information. So they just don't know what the true universe was. And that's not how investigations usually work. Investigators go and gather the materials, they go and get the questions answered, and then that puts them in a position to negotiate with defense counsel. Here, defense counsel was able to run the show.
So Gary Shapley was alleging that David Weiss, obviously the man leading this investigation out of Delaware, was seeking special counsel status to be able to prosecute in different jurisdictions outside of Delaware, in California and DC, but that was denied. David Weiss's letter on Friday night basically admitted to doing that. What does this say about the investigation, and how much of Merrick Garland's testimony about not interfering in the probe was contradicted?
Well, Weiss's letter was nuanced, and certainly for Weiss to acknowledge that he had to receive, permission to partner with other U.S. attorneys, we believe strongly supports Gary Shapley's testimony and again contradicts what Merrick Garland has said. What Weiss didn't touch on is whether he had already requested special counsel authority. He says he's been assured in the future he will be able to get it. And so that's the million-dollar question. Did David Weiss, as he told investigators from multiple agencies on October 7th, 2022, previously asked for special counsel or special attorney authority? And if so, was it denied? And who did he ask it of? Those are all questions Weiss needs to answer. So far, he's avoided answering that question. Weiss's letter was kind of a masterclass in obfuscation in admitting more than has been admitted until now, which was significant, but still not getting to the crux of whether Weiss was stopped from bringing charges in the past, which is what not only Gary and other witnesses have been told, but what the evidence points to. Why else would the Delaware U.S. Attorney's Office have allowed the 2014 and 2015 charges to expire, other than the reason that they gave to Gary in October, which is that there's no point in keeping the negotiations going on, extending the statute of limitations with Hunter's defense team when there was no venue to prosecute in. So again, the fact that they allowed those to expire strongly supports, I think, the allegations that, in fact, Weiss couldn't do anything with those unless he could get buy-in from DC U.S. Attorney Matt Graves, who allegedly refused to bring the charges there. There is some interplay of the dynamics between, again, investigators and prosecutors that you see, and then prosecutors of different districts, but not usually with a case this significant and with charges that are this straightforward and with this much evidence.
Did Gary Shapley and his team ever come across that FD 1023 document that allegedly details a bribery scheme between Joe Biden and a Ukrainian oligarch?
Gary submitted an additional affidavit to the House Ways and Means Committee identifying that he has not ever seen the FD 1023. He was not aware of the 1023 or of the substance of its allegations, and that if he had been aware, that would have been very significant and relevant to his investigation, which was all about how the money from Burisma was moved, where it was going, who was receiving it. So this was news to him, and it was very, very big news to him that such a document existed in the possession of the FBI.
Would it be the normal process that the FBI would hand it over to Gary and his team to investigate as part of their probe into the 2014 Burisma taxes?
Again, there are some ways that this is unusual. So there's not a standard in some ways for much of this, but typically, yes. If the IRS and FBI investigators were working side by side throughout the investigation, they shared information with each other, they shared evidence with each other, they questioned witnesses together. So in a typical investigation, if it was all being run out of one office, that's absolutely something they would have seen. The part of the unusual nature of this is what former Attorney General Bill Barr has identified, that there was a lot of information cropping up around the country with allegations about the Bidens. He felt that it needed to be vetted, or at least in one place needed to be checked for signs of disinformation, and that these allegations, did not show signs of disinformation. And so it should have made its way to Delaware. It should have been in the hands of the IRS and the FBI investigators. It's absolutely something that Gary should have seen. Yeah.
Well, on that note, Gary testified in his testimony to Congress that the FBI had verified the contents of Hunter Biden's laptop in November 2019, which is obviously 1 year before the 2020 presidential election. And they didn't seem to intercept the narrative that it was an example of Russian disinformation. What is your client alleging about the role of the FBI from what he's seen?
Well, the FBI had possession of the laptop, but it was really the decision of the prosecutors to decide who received what. But the laptop itself not being accessible to the IRS was a significant problem. The FBI only obtained it because of an IRS warrant or IRS authorization to review the contents of the laptop, because the possible charges were tax charges. And so that's what gave them the access to investigate under the U.S. legal system, where you have to have some predicate, you have to have a reason to look through and search the contents. The FBI had it in their possession, but they didn't have any potential charges, and that's what the IRS provided. And so again, in any other investigation, it would have gone to the investigators, and Gary would have been able to see a full readout of what was on the laptop, similar to other investigations where the evidence is all provided to the investigators.
Tristan, has the White House contacted you at all?
No.
Has Hunter Biden's laptop, his attorneys?
No, they put out a statement last week, which really walks the line in U.S. defamation law by insinuating several things about our client. And suggesting, not only that he had improper motives, but that he broke the law, or that he was the subject, that he was an individual to leak information to the press. And so, we are addressing that and responding to that information, but we haven't had any firsthand contact. I don't anticipate that we will. But, those who have had contact, for instance, Chris Clark told the prosecutors last summer that if they were to charge his client, it was a career killer. And so I can't imagine that any contact with them would be of a positive nature.
No. Just finally, Tristan, based off what you and your client have examined, how possible is it that Joe Biden is lying when he says that he has never spoken to his son about his overseas business deals?
Based on what Gary knows, there's just not enough information to say one way or the other. Obviously, there are allegations, there are investigative leads that need to be followed up on, but none of the leads that Gary has been allowed to pursue thus far give the answer to that question. There is certainly public reporting out there of things like phone calls between President Biden, or then as VP or after he was out of office, discussing some elements with Hunter, and so again, that comes from public reporting, and that raises further questions about the denials that President Biden has issued. But ultimately, it's just clear there are a lot of other elements that need to be investigated, because these significant leads really raise a lot of questions about the role of Joe Biden in the whole Biden family enterprise. Whether what the judge does or what anyone else does in this instance to say there's a whole two-tiered system is I think a fair accusation to make. But at the end of the day, what Gary wants is simply for the public to understand what happened, and for Congress to be able to ensure that in the future nothing like this ever happens again, that investigations like this have the independence that they need, and that when you have such a high profile individual, such a politically connected individual, that's treated the same as everyone else. That's Gary's chief goal, and that's the system that he is striving to ensure that we have in the United States.
Tristan Levitt, thank you so much for your time.
Thanks so much, Maddie.